if you as a solicitor have a client coming to you telling you things that you may not necessarily believe, it's not your job to believe it. That's up to you to try and persuade a judge to believe it. And you have a duty to put your client's case. So when I was first asked to do this by Mike, I said no. And the reason I said no was because I don't see myself as an expert. I only see myself as a solicitor who's been doing this work since starting articles in 1983. But I suppose when you look at it, I've been doing it a fair amount of time, and I instinctively nodded when Sam Morphy asked, "Is that a tactic?" Because he's not wrong. All right. And I haven't prepared any notes, but I've been making notes as this meeting's gone on. And if I could just start with what the law used to be, we used to have custody orders and we used to have access orders, and everybody understood that. I still have, or used to. I stopped working as a solicitor now. I'm working with Nick Fletcher in his office, but I would constantly get clients coming to me in the 80s, 90s, noughties, and the 2010s asking for custody orders and access orders, and that terminology is still there. Now, we moved on from there with the Children Act, which was passed in 89 and came into force in 91. And we had residence orders and contact orders. And then that was determined not to be politically correct enough. And so we ended up with live with orders, whatever they may mean, and spend time with orders. Now, when clients go to court, they do believe in the majesty of the law. And I don't think an order that calls a live with order isn't very majestic. It's not very impressive. And I think that clients personally would prefer the old system, the old terminology, than the brave new world that we started up with in years gone by. Now, obviously, as a lawyer, when a client comes to you, you have to explain what the law is to them. And the law is that the welfare of the child is paramount, that the court will only make an order if it's in the best interest of the child or children. But when your client has a particular mindset, has a particular belief, as a solicitor, it's not my job to be the judge. It's my job to be the representative and to put forward my client's case as best I can within the legal system, ethically, etc. But the reality is that if my client wants to achieve a particular outcome, and my client believes that that outcome is in the best interest of the child, unless they're committing some sort of criminal offence, am I supposed to tell them, no, you can't do that? Obviously, I'm going to say, well, the judge may disagree. I mean, the client may come to me at midday and tell me that it's pitch black outside, but I've got to persuade a judge that that's the case. And obviously, I'm going to use esteemed counsel like Catherine and Alan to make that point. But the reality is that if the client is of that mindset, then all you can do is work with that client. And when Sam talks about tactics, I think he's right. I do think that there are tactics, and I don't necessarily think that they are lawyer driven. I don't think necessarily that every solicitor who does what used to be called legal aid, public funding, will say to a client, well, either invent abuse or create it, so create circumstances where you are abused. But the reality is that people aren't stupid and they talk to each other. And when you have a system which is where you don't have a level playing field in the first place, I always found it far more challenging to act for a man than a woman. The system isn't geared up for men at all. The best that a man can hope for is equality, and the worst, whereas that's the starting point for a woman. You have a situation where the level playing field then not only is not level because of the law and the system, but then gets even worse because the man who's working can't get representation. He doesn't earn enough to afford representation. And the female partner can get representation if she's got public funding. And whoever has a live with order for the children, whoever has de facto custody of the kids, it's a really important thing because it means that that parent has priority need in terms of housing with the local authority. That person will receive more benefits and that person will receive child support. Now, if you had a situation where Philip Marcus at the previous meeting was talking about equality, 50-50, then under our present system, no child support would be coming in the way towards the woman. And there's a clear financial incentive for that level playing field, in her opinion, well, unlevel playing field to remain that way. So when Alan talks about looking for the common ground and not emphasizing the differences, I can understand why you say that as counsel, as somebody who's got to make the final decision in a court case, but there's a long, massive amount of time between a client coming to see the solicitor and you delivering that judgment in a courtroom. And what happens in between then those two stages often determines the judgment that you're going to give. Because if you, I have clients who've come to me and they've said, look, she's taken the kids and, they've left our house in Doncaster and now they're in Kent. And I've gone straight away to Crown Court, well, not the court, it's not the Crown Court, is it? But gone to a circuit judge and got an interim order for the children to be handed over forthwith. And everybody was completely astonished that you could do that and achieve that for a man. But it can be done. But if we hadn't taken action immediately, that lady would have ended up with the kids. I know she would have done. And in the end, the kids stayed with their father. He was the one who had the interim live with order. And whatever happens at the beginning is usually what happens at the end, as I'm sure any fellow practitioners will confirm. It's very, very difficult to turn that one around if you haven't got the kids in the first place. So I don't really know what you want me to say, but what I can say is that the system is totally unfair to a man, and the system is unfair, the law is unfair, the procedures are unfair, the public funding system is unfair, the child assessment system, child support assessment is unfair because it militates towards him having less time with the kids. The more nights that are spent with her, the more money she gets. And unless or until we change any of those things, I can't really see a way forward. But over the years, I've moved from being somebody who I suppose would have been totally in accordance with what Rosemary was saying at the beginning, to somebody who's now saying, well, actually, this isn't right and it's wrong. And what we should do is we should have a starting point that isn't woolly, it's there in black and white, and it has to be 50-50. And unless there are very good reasons to deviate away from that, that's what it should be. And if you don't comply with that, then we should be enforcing it. I had one case in America where my client had an agreement, a court agreement with her husband, and he was due to have the kids that weekend, and one of them was ill and didn't go. The other one did. She then had to explain to a judge why she shouldn't go to prison. Now, that could never happen in the UK, never. But I was talking to the attorney in the US, and I was saying, no, this can't be real. And she's going, oh, no, absolutely. This is dead serious. And if your client comes back to the US, she will be arrested and she will be taken to prison. And that kind of system may be too extreme, but clearly over there, a father does have rights. Whereas over here, it's always what's in the best interest of the child. And if the child is being influenced by the mother, which is not too uncommon, we all know the outcome of that. And that is that father doesn't get to see his child, or gets to see that child far less than he should. So I've got loads of notes written down. I'm also a qualified mediator. I could talk for hours about how mediation is abused, but I'm aware that time is short and I've gone 1 minute past my 10 minutes, so I will shut up.
Thank you very much. Could you just answer one question first? There's this term, best interest of the child. A point was made at one of our other meetings, was that this doesn't have any meaning, because the meaning of in the best interest of the child is whatever the court decides it is. Do you think that's correct?
Well, I think so, because I mean, let's say you start off with a situation where mum and dad are fine, they're coexisting, and then they separate, and then mum decides that she really doesn't like him because he's probably slept with somebody. She can then, and I've had cases where this has happened on both sides when I've acted for mum and against mum, where she has influenced the child not to go, not to want to go. And by the time it ends up in the courtroom, that child has a settled view. And also, there's been a long period of time where there's been minimal or no contact. And in extreme cases, you end up with a situation where the father loses contact completely. Now, that is an extreme case, but in order for that father to get that far, he's got to be prepared to spend the next 5 to 10 years going through courts, you know? And when you have a situation where there are, is it 20 committal orders were made in regard to parents who didn't comply with contact orders? When you have a situation like that, it's quite obvious that there is no teeth. And if there are no consequences for your action that will penalize you, and in fact, any actions you take may actually benefit you as you see it as a parent in your misguided way, that's the way it will be. And, you know, barristers come into it very late in the day, judges even more so. And academics at the end of the day, you know, so what happens is determined, in my opinion, in the very, very early stages. And if you don't take action then, if you don't have a system that provides some stability, some strength for the rights of both parents, it will continue to be abused as it is being now.
Okay, that's great.
Which is why Sam has to do what he does.
So questions, please.
Is some of the answer there solicitors being a bit more robust with clients when they're interviewing them about legal aid? Because one of the things I've noticed is there are a couple of firms that churn out non-molestation applications quite readily. When I've landed on my desk, some of them you think that you're never going to get this order because it's you know it's doesn't go far enough, you know, it's just a bit of mean behaviour. But they've clearly got legal aid for it. And is that not the responsibility of the solicitors to make sure that they're not reading that sort of application?
Well, I mean, we saw some immigration solicitors in Manchester hauled off to court the other week, didn't we, for abusing the system. I mean, when there's a financial incentive to a solicitor to get legal aid for non-mol and also to get, which will then give him legal aid for Children Act proceedings, what am I going to say? I mean, not everybody in the profession, I mean, well, not everyone's perfect, are they? So, and there will always be that scope. But I mean, you know, Alan was really spot on, because he was saying, well, he wasn't surprised. He was surprised only 40 to 60% claiming domestic abuse, because the definition of abuse, and I quote you, is that there's a very wide definition of abuse now. And if you give your wife housekeeping, that is abuse. And you could argue it's abuse, it's financial control under the new legislation. Now, all I can say is that the system is well-meaning, and I have no doubt that the people within it are well-meaning. But I also know that not all clients are well-meaning, and they will do what they need to do. And if at the end of the day a child is living with his mum, and the judge takes the view that that parent is totally out of order, that judge is not going to, he's got to do what's in the best interest of the child. And he can't, is it in the best interest of the child to send that woman to prison? No, it's never going to happen. It's never going to happen. So she can do what she likes.
Okay.
Do you think there should be, just to follow up on that, do you think there should be a positive duty to report a change of circumstances to the legal aid?
There is already, but I mean,
I think at the moment, isn't it down to inquiry? They make a periodic inquiry.
At the end of the day, I used to do a lot of legal aid until, I mean, we were the largest legal aid firm in the Southwest when I was in Bournemouth. And the situation is that most solicitors, and I'd say 99% of solicitors, are really good, all right, and are, there's no problem with them at all. There will always be some bad apples in any organization, but I've no problem with solicitors per se. What I'm saying is that if there was a reason why they would take legal aid away, then they would do that themselves. But the reality is the system is there, and if you as a solicitor have a client coming to you telling you things that you may not necessarily believe, it's not your job to believe it. That's up to you to try and persuade a judge to believe it. And you have a duty to put your client's case. So, the solicitor shouldn't be the judge. The solicitor should be the advocate, the representative. And you have a system that's in play at the moment that is easily abused and is abused, in my opinion. And the reason why Sam and people like Sam having to step forward, and full credit to you, Sam, for what you do, is because of that. And nobody, you can do as much research as you like, but if you go to a solicitor who is telling him all the wrong things, he's not going to tell you that, is he? He's not going to write that down. He's not going to have it videotaped. There's no evidence whatsoever that that's going to be the case. And the client, who effectively would be his co-conspirator, isn't going to want to get dobbed in either. So if it happens, it's something you'll never have any concrete evidence of.
I agree with Andrew that it's important that there should be a presumption that both parents should be involved in the life of the child. Unfortunately, that presumption doesn't exist, and the best interest of the child is very much left to the judge, who can be influenced. So presumptions are very important here. I've written about the defects of the legal aid system and the non-level playing field. We've spoken about that. Just wanted to tell you, I spent most of today drafting an article on the decision in Reed T, which came out at the weekend. This is a case that took 10 years, 70 hearings, 26 judges, a total failure of case management, an abusive mother stopping the child from having contact with the father, and the courts were toothless. And I don't know if that's because solicitors don't know to ask for contempt of court, whether judges don't believe that they have the power of their own motion to invoke contempt of court. And I don't agree that sending a mom to prison for 3 days is going to adversely affect the child if dad's around there and can have the child during that period. So there's a need for a lot of changes there, and we're working on that in the document that Mike is so ably producing.
Thank you, Alan.
Yeah, I was just going to pick up on this point about non-molestation orders that was raised and obtaining legal aid for those, because I mean, this is where I find it interesting to draw parallels between the family court system and what I've seen in other areas of civil practice, because there was a problem, as been alluded to, in the administrative court with urgent applications being made by immigration solicitors where that wasn't warranted. And there's now a procedure called the Hamid jurisdiction. It actually involves the solicitor being summoned before the, I think it's president of the King's Bench Division to explain themselves. And it isn't professional for solicitors to make, especially ex parte applications, where that's, so ones without notice to the person against whom the order's sought, where that's not warranted on the evidence. So I think that's just highlights kind of cultural issue where perhaps a little more procedural rigor and strictness would actually be a benefit to children.
Okay, final word to Andrew, and then Nick might want to say something just to wrap up.
Okay, if I'm the only Andrew, I assume that's me.
Yeah,
I think that like Philip was saying, if we had a starting point, we don't have a starting point at the moment other than mum's going to get the kids. And that's, I mean, when you have a child support system which actually actively rewards the mother for restricting overnight access to the kids, you're inevitably going to have issues. You're inevitably going to have problems. And these are not people who like each other. And I just think that it needs root and branch reform. And I don't have any confidence that is ever going to happen in my lifetime.
Okay,
So,
I shouldn't worry about it, Andrew, because Nick is going to sort it out for us. Do you want to have a final word, Nick?
No, only just to say that that's been a very frank conversation. I think you've all added something to that, and I hope you all found it worthwhile. It's obviously an extremely difficult issue. There's no two ways about it. But I think it's only by speaking frankly that we have done, and people coming together in their own time, that we actually stand a chance. Now we have some more evidence sessions. Everybody on this email address has got my email address. If they would like to get in touch with me and send some more information through, then please do. We've always got to keep an eye on the actual the goal, really, which is, I mean, my personal goal is to obviously, if there is a separation, is to make sure that the children get to see both parents and it's as amicable as possible, because I think the lives are too many lives are destroyed by parents that have not been able to do that split without causing so much anguish for everybody involved. So, as I say, the offer's there. I'm happy to speak with anybody anytime on this, and hopefully, with the help of Mike and Mark Brooks, who's joined, and Andrew, who's actually sat at the side of me, we can pull together a report, and we can get government to actually listen, because I do believe it's one of the biggest issues society is facing. So thank you very much, everybody. Much appreciated.
Thank you all very much indeed, and good night to you.